In Michigan, a defendant already facing a bond violation picked up a new felony charge. While he was first granted bond for the new case, his actions quickly backfired, and the judge wasted no time raising the bond to a higher amount.
Start your video and unmute yourself, please. Calling the case number of SP 4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy because I would like to note two things. You're driving at a disgusting rate in a construction zone.
Mm-hmm.
You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background. Never roll.
Okay, well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
For his bond violation, the defendant lost a $25,000 bond set at 10%, meaning $2,500, and will now be held without bond until his next hearing. The court then sets a new bond for his fresh charges, But things escalate further after he loses his composure, leading to an even higher increase.
Welcome back. So we're going to begin in case number 25-4703FY. Mr. Ullum is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullum?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ullum's rights in this matter. In regards to the underlying charges, Mr. Ullum waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So we'll appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ullum stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and to counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bond bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ullum, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week, and we'll make sure that the hearing is expedited.
He started with a $10,000 bond at 10%, but after his outburst, it was quickly raised to $25,000 at 10%. Moving on to the third and final hearing, we meet a sovereign citizen who believes he can live rent-free for 18 months simply by claiming his past debt has been discharged.
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ullum as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ullum waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pre-trial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Ferrara-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood-altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No, Mr. Ulam. No, Mr. Ulam. No,
What address?
Mr.
What address
Ulam.
again? What address? I'm just confused. I just wanted to repeat I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you can't be at any address that Darcy Robinson is or may be. You may not be within 500 yards of her.
I understand. No, I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless and I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? You took my phone. Hey, tell Darcy Robinson not to bomb me out again too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Ulam, and it's going to be a $25,000, 10%.
This isn't a federal issue, so Article 3 courts have no role here, and state courts have full jurisdiction based on the complaint. Your consent isn't required, and after 18 months without paying rent, the property owners simply want everyone still living there to vacate.
All right, parties. I'm going to figure out, and then we'll determine whether or not how we're going to proceed, how we're going to continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year on every.
Yeah, every,
okay. All right. So technically renewed again on March 2025, but I understand that there's allegations of default before then. So how much is monthly rent?
$1,750.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The loss discount is $100, and then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at 175, which would be the most. When's the last time the tenant paid rent? How many source?
That was on the ledger there. It was February 25th, 2022.
That's the last time he paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly, and the county stepped in and
Objection,
paid.
Your Honor.
Oh, okay, well, he can tell me what he wants to say. Overruled. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times, and some weeks at a time. So I'm not sure what was filed.
Well, that's a concern because you're pursuing this. And we've got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. Well, for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers because the numbers that you're asking for in the complaint that was past due in April of $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but so he hasn't paid rent, at least according to the complaint, since then, and you guys have not received any monies since December or since November at all, or at least in some.
That's correct, Your Honor. Not that I'm aware of.
Okay. All right. Well, just hold tight. Let me speak to Mr. Stevenson. So, Mr.
Yes, sir.
Stevenson,
What's going
when did the initial lease get signed? You recall?
on? Yes, sir. It was signed probably in I want to say 2019 to 2020.
Okay. When's the last time you signed a lease?
The last lease I signed was probably in 2022.
Okay.
I would like to say that I'm perfectly fine with answering all your questions, Judge. Nothing. I've filed a lot of evidence in this case showing that they have not done their due diligence whatsoever in this proceeding, which you've already recognized to a degree with their misnumbering of their own numbers. But I don't. I'm challenging the jurisdiction of the court. I don't believe this belongs in this court. I reserve all my rights, and I do not consent to administrative process and without equity, according to Article 3.
From December 2023 to June 2025, no rent has been paid, so it's probably time to pack up and move on somewhere else.
With due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000. He's saying that they just submitted a ledger to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger,
but
so
he,
I don't
he just said it in
assume
mediation. I'm not assuming.
So just hold tight.
Yes, sir.
Why don't
I'm just saying I got a lot of stuff, and it's a
you
real
let me
case.
just, and then we, if need be, I can get into all of that because right now,
Yes, sir.
one, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So,
Yes.
so I all of that. That's why I like to ask my questions, and
Yes,
then
sir. I just wanted to make sure I got on record that I do challenge that we should even be in this court.
And I would say, if that's the case, did you file a?
I will.
But you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get it removed just to Superior.
Okay, and under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant-landlord situation.
I would pause you because I'm very familiar with that. And if it's a rent-to-own situation, those generally are still considered contracts. You may have a lease, otherwise. And so, just before we get into that,
okay,
because I've been doing this a little while. So,
I'm with you.
All right. So tell me, is rent $1,750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in 2020.
The contract that I signed, the rent was not. If you review,
oh, how much is it? How much is
the rent that I signed at the time? The contract was $1,450.
Okay, $1,450.
It was $1,450.
Just getting information.
Yes, sir. Okay. I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on. Let me do my job. Okay.
Oh, my bad.
So you're saying the last rent is $1,450. Was there a late fee associated with that $1,450?
I believe so.
Okay. And let's just say for giggles, because we only gonna give them 10%, there was $145. Right. So tell me this. When is the last time you paid rent? Or anybody on your behalf?
I believe the last time that I paid rent would have been in the year of 2023, December of 2023 or so.
Even if everything you've said were true, missing payments on a rent-to-own contract usually allows the landlord to end the deal, meaning any equity you built up is lost because of your failure to pay on time.
Okay. And so, just to kind of get some clarity, December of 2023, that means all of 2024, And now we're moving into 4 full months of 25. And then if I were to give a writ, right, you would have 7 days. I understand you saying you ain't got no jurisdiction, all that stuff. I just want to understand what I'm working with. So it essentially would have been 16 months plus 13 days. Now, that's not what they're asking for.
Correct.
But you're saying you haven't paid rent at least for about 16 months.
Correct.
Okay. And is there any basis of why you've not paid rent for 16 months?
Yes, sir. They have some funny accounting. And so I submitted in accordance with UCC and all other statutes and legal statutes. I submitted a request for accounting, a full request for accounting, which I have a right to do. I submitted it under certified mail to the registered agent's address per the law. The registered agent received the first letter. I have all received, everything's in front of you in the submitted stuff. I submitted a document requesting a formal request, asking and saying that I would pay whatever was needed as long as they produced actual documents, especially because they're filed under a trust. So they're supposed to complete certain things as a part of their business model of how he's even running his business. And so I asked for that to be produced, and I would pay. The first one came to them, they received it, then they closed it back up, taped it up, and they rejected it. I sent 2 more. One of them I sent notarized, which is the big envelopes you have. I sent a notarized copy. You also have a copy of what I asked and requested from them under the law. They ignored them 3 times. Then didn't ask for any rent for a year, Your Honor. And then when they did send me a notice to pay or quit, it was for $6,500, and now the $7,000, which is what you're looking at.
Okay, so let me pause. Let me pause because there's a couple things going on, and I don't know. You may not like what I'm thinking, but I'm just. You got 16 months past.
No, I wasn't at the time, Your Honor. I wasn't at the time.
I got it, but now 16 months past.
Yes, now.
They're asking for 7. When did they demand 65?
Today.
Okay, so did you get any notices about this hearing, or about this action before?
No, he said all this
it was filed against you?
He submitted new documentation today in mediation. He said he submitted it today and that y'all received it in court for $65,000. I have no knowledge of that.
Okay, well, pause. This is an important thing. It's important. I saw your defenses that you raised. Mr. Brown, can you tell me when or send Mr. Stevenson a demand of possession?
When was it sent to him? There was a pay or quit notice, and I do not know when that was sent to him, but I might be able to find it in the file.
That's going to be huge.
Okay. I believe the pay or quit was very recent. I believe it was last month.
Last month when?
Let me see. I have this pay or quit. Oh, here's one from July of 2022. Here's one from July from 2021.
Let me see something from 25.
All right.
I have it, Your Honor. It's 3/15/2025.
3/15/2025.
Yes.
Okay. And what did it say?
It said undisconnected rental rate $1,750. Rent from January to March $5,250. Additional daily rent $10 per day at 92 days $920. Recovery $75. Existing unpaid balance $321. Total due 3/20/25 6566.00.
Okay, so how much is that? Tell me how much they're saying is due.
$6,566, Your Honor.
Okay, and then when you got that, what did you do?
I filed with them a failure to contract, a no contract notice, and I refiled with them the notice I filed for them to give me proper accounting with the certified notary from the year before that I tried to file to them that they rejected because he's using a PO box as a registered.
Are you alleging that you paid too much money to them?
I'm alleging that I have equity in this home and that the stated amount that they are saying.
That's not how it works. You can't sign a rent-to-own contract, skip payments for a year and a half, and then magically claim the debt is wiped away.
All right. Equity in this home. Neither one of you submitted a contract. So tell me what
I didn't file a complaint.
Well, but you're having a defense that you have
I do have
equity
a
and
defense
rights in this property, right? So
because
it's
they
your
left me alone.
responsibility. So listen, it's your responsibility to put up all the necessary defenses to
You,
support you, right? And so what I'm saying is, you're saying you have a special kind of lease. So tell me what parts of your lease, since I don't have the lease here with me,
we
justifies
had
it. Well, hold on. I
okay.
guess Mr. Brown was going to answer that.
Oh,
Mr.
well,
Brown, does he have
I thought you was okay.
okay. Do you?
I'm fine. I'm quiet. I ain't said nothing, man. I'm good. I thought you was talking to me, so I thought I was
I
supposed to
was.
answer.
I'm sorry, but you were just going. I just want to know what part of the contract. How do you have
Okay,
it? You have a lease to own? Is that what you have?
it is a rent to own. It is a rent to own where you're only supposed to be in it 3 years, and then you either basically leave or you're in a ownership position. I have to do my own maintenance. There's no, that's not me. That's coming out from my side. There's no, they don't come do a bunch of maintenance. I have to fix my own back porch. I got to do, you know what I'm saying? So what I was asking for a year ago when they came to me saying, hey, you owe some money, I felt like the accounting was off. And so I asked to see the accountant. They refused to show the accountant. That's it.
All right. All right. Mr. Brown,
Yes, sir.
a lease to own agreement?
I'm just looking back. It would have been long expired if there was one. I'm just looking back right now because we we do have a rent to own opportunity, and we do help deserving families end up with home ownership regardless of credit or financial background. So we work that into our program, and we give people up to 3 years to buy. And so when he signed in 2019, that would have been expired by now. And I'm just looking back to see if he even did that.
I'm not going to further delay this. This is what I'm going to do. I'll be honest with you, Mr. Stevenson. The initial facts, and because of the history I have with these cases, I would argue that they would be entitled to a writ. Particularly the amount that they're seeking is a lot less than what you would normally be paid because of. But guess what I don't have? I don't have a contract. And you make an argument that you may very well be entitled, but I don't have it. And depending upon the language of that contract, will really make a determination of how I proceed. And so I'm going to reset it for in person. I don't necessarily believe that there's a basis for it to be in Superior Court. Those issues, based on the contract, may reveal that that's not necessary, particularly if you're not alleging that you've paid all this time or have submitted to them a opportunity to purchase and they didn't accept it. That's a different. But just saying that you have a lease to own, but then you've defaulted on it and you're very well entitled somehow to some type of equity. You might be entitled in a separate action and maybe some of the improvements that you've made, but that may not prevent them from being able to get you evicted. And that's a fact. That's
Your
a
Honor,
fact.
can I ask a question?
Sure.
Okay, so the fact that I still have a UCC's claim, 100%, they did not respond to my request for, I have a right to accounting. They blocked it. What about the
But
fact
that
that
may
they
not
also,
prevent me from dealing with possession. See, I think you
oh
misunderstand.
no, I'm not saying, I get that that's what this is dispossessory court. I get
It's a
that's
dispossession.
why I asked to have it removed to a higher court. What I'm
But
saying is,
you need to file that stuff. The
well,
Superior Court
I
is not a
will
federal
file it
court.
because I don't want to be put through this administrative process, which this basically is, and it's just kind of a quick kind of will and deal thing. And he's got legitimate. I have legitimate things that I'm saying. I asked for accounting for debt, and then now for them to submit a debt of $65,000. So what you're telling me is we're going to come to meet you, and we're just going to discuss the $6,500 and not the $63,000 that they're trying to put on the ledger now.
Well, I'm going to be honest with you. If you ain't paid rent in a year and